Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from 11 Publishing, who are based in The Hague in the Netherlands. It's an important book in a series that they've produced which has direct relevance to the English common law. The title of the book is Constitutional Review and Democracy, and it's got a subtitle, Democracy and the Rule of Law, and it's been edited by Miodrag A. Jovanovic. I hope I pronounced the name correctly, apologies if I haven't. Now, my wife Elizabeth and I have looked at this book and had a discussion about it, and we gave it the title for our review of the following: Constitutional Review Explored in an Era of Change. And that's really what the book is about, because we're looking at perhaps aspects of judicial review which you might not have thought of, and possibly some changes that may take place. I'll talk about that in a few minutes. Let's have a look at the book first of all. Here it is, the paperback. Not a particularly big one. Spine, and then the back there you can see there is a little bit of blurb on the back, but not a lot, just explaining basically what's in it. And then you can see right at the last page, there's no index, but it runs to just under 300 pages. And this in fact is the last of the essays. But let's go straight to the front though. You can see there is the main front page, and then after that you've got the list, and that's the first page of the list of chapters. Each one has a chapter heading and the name of the person who's written it, and then you go over to the second part, split into different parts, the book. In fact, let me just explain that. Part 1 is general aspects and theoretical problems. Part 2, constitutional review beyond the nation state. 3, constitutionalism and democracy without review. In other words, no fail-safe mechanisms. And 4, constitutional review and democratic transition. Then you've got a note of the contributors. Not very much of them, but very, very highly qualified people. Then there's an introduction by the editor. And you can see there are very substantial footnotes in places which are very helpful. It's not a particularly long introduction. Then we go into part 1 itself, general aspects, and then you can see how it's structured. There is a bit of paragraph numbering. There's no index, so you're not going to find things by that method. And then it's actually the footnotes. So it's basically one of these documents that you look at a chapter and you just read through it. You do have some quite useful things like a concluding word or a conclusion, which tends to bring things together. It's an interesting volume anyway, and it's as a result of a conference, but more about that when I talk about the review itself than what we've said. This is what we say about the book. Does constitutional review actually affect political change? And if so, what are the circumstances in which it might work or might not work, and in what ways does it affect or possibly undermine the democratic process? Now, those are the sorts of questions we're talking about, and I submit that they are probably directly relevant now to the UK because of what has happened in Scotland with the huge number of seats which the Scottish Nationalist Party achieved at the general election earlier this year. I'm recording this review in the middle of 2015, so we've now seen a change, and the question then with further devolution and powers being transferred is the question, certainly for the next decade, is how far constitutionally can these people go, if I can put it as crudely as that. So that's something which I think in the long term will be of interest to a lot of scholars and a lot of people who are watching events unfold. So these matters which I've just raised, and any number of related queries which are probably going to crop up, are examined, discussed and analysed in this excellent new book, the Constitutional Review and Democracy title, in a series of books. It's a compilation actually of 13 learned treatises on this what is often difficult and controversial subject, and it was presented as part of the Conference on Constitutional Law and Democracy in November 2013 at the University of Belgrade's Faculty of Law. An excellent faculty. I've met quite a few of the people from that faculty from my time doing a number of presentations to them, to the judiciary there, on the common law as we have it in England and Wales. So I thank them very much for what they have done, the contribution to the debate. because we are actually part of Europe, and it's an important area to make sure that we have our rule of law and our common law clearly set out for our cousins, if you like, on the continent. Now, as I say, this book has been published by 11 International Publishing, who are based in The Hague, Den Haag, and the book has been compiled under the editorship of Miodrag A. Jovanovic. I hope I've pronounced the name correctly. He's the professor in the Faculty of Law at Belgrade. It is in fact something that's emerged as a follow-up to the conference that took place, with a view to shedding new light on what Jovanovic calls the complex relation between democracy and judicial review of constitutionality, and an intricate relationship that is between democracy and constitutional review. Now, you will recall, which was not mentioned here, but you will recall the United States of America model and the way in which the Supreme Court justices can review. We don't have the same thing here with the Supreme Court in the UK yet, but it may well be that things change, so watch this space. The resulting essays in the book are grouped under 4 categories. The first, which deals with the general and theoretical aspects of the debate, kicks off with an article by Professor Mark Tushnet of Harvard Law School, in discussing what he identifies as transitions from authoritarian or dominant party regimes, in other words possibly dictatorships, to competitive party regimes, i.e. democracies. And he says that such transitions provide a focus for an examination of the political conditions under which effective constitutional review can be established and sustained. And the overall aim here, as is the rest of the volume of the articles, is to postulate by much criticism and examination the various ways and means by which constitutional review can be established across a variety of governments and legal jurisdictions, as is the case, for example, in the European Union. And as I've indicated, the book is separated into the various parts, and in particular Part 2 then goes on to deal in considerable detail with transnational issues pertaining to the EU, which are very pertinent in the 21st century as we develop our relationship within the EU and outside it. It's also important to note here the article by Tanazny Marinkovic. I'll start that again. I think it's Tanisi Marinkovic, on authority of European human rights law, lessons for constitutional law. Again, I think that's an important area because human rights is high on our political agenda within England and Wales certainly, and the United Kingdom more generally. And also in the section, do have a look at the article by Dragolub Popovic, who's a judge of the European Court of Human Rights, and he looks at the possible need, especially in nascent democracies, to ban certain political parties which set out to undermine the very democracies of which they are a part. An interesting point which I'm sure you will find of interest as you go through the book. And as I've said, the book itself is one where you can actually read the essays bit by bit, and don't bother too much with the footnotes. Of course, one can offer only a flavour here of the rich vein of commentary and analysis available to interested readers in what is a thought-provoking book, part of 11 Publishing's Democracy and Rule of Law series. And of course, with its team of expert international contributors, it certainly provides valuable insights into the processes by which effective constitutional review has been implemented, actually with varying degrees of success. That is in the different nations, particularly those in which democracy is a fragile flower indeed. And that again is another reason, and I'm not advertising this here, another good reason why we have the European Union. I believe obviously it's basically economic, but there is that there always will be that political element in terms of common ideals. That deals obviously with trade, but it also deals with other matters. And as I say, the fragility of some of the democracies we have is something we want to nurture. Now let me conclude by saying that Academics and graduate students seeking a deeper understanding of this area of law will certainly find this book useful in our view, and the publication date is cited at 2015. Let me just show you the book again. There it is. That's the front, and then there's the back. I'm just opening it in the middle. We're looking here at Ban on Political Parties. You can see again, just to highlight what I've said, you've got the paragraph numbering, you've got footnoting, but it's relatively easy to read. I think they've made a really big effort in terms of the translation to get it as right as it can be. Then you've got conclusions, always useful with any essay that you're looking at. You know, you really must have, which you have here, the introduction, the middle bit, and then the end. That's on Lingering with Intent, the UK Constitutional Review. An interesting contribution itself by Vito Breda. Now, I'm very intrigued to see how popular these books will be on the international stage, because I do think they have a very great value for international jurisprudence generally, and I do hope that you know, if you find it interesting, it's one that you will have a good look at for the future, because these books are very much a commentary on where we are today with the rule of law as it applies in Britain and elsewhere. So thank you to all the people concerned for an excellent book. Bye bye.